Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone, and welcome back to another live stream with me, Gisela K. This is Grizzly True Crime, and today we're going to be talking about the Delphi case. Because of course, it's a massive day in Delphi, Indiana, in this double homicide case. Let me just take this off, it's going to distract us with the ads. And of course, there's the hearings we've been talking about for quite some time that's happening right now. There was one that started at 9 o'clock, and there's another one that's happening at 2 o'clock. We're going to go over that little article now so that we could just all be on the same page of, what this hearing is all about, especially if you've missed any of the other updates that I've done already. Welcome to all my moderators. Thank you so much for everything you do. Welcome to all my patrons, all my members, subscribers, everybody. Everyone that's new as well. Welcome. So this case is just very concerning. My word. And the more that happens, oh my goodness. It's just like, wait, what now? The more we read, it's just horrifying. I can't imagine how the families are feeling. I keep saying that. Like, what is going on in this case? Okay, so let me tell you what the hearings were about. Just give me 1 second. Let's pull this up again. So they say, here's what to expect in Monday's hearings in the Delphi murder case, right? So, Delphi, Indiana. Delphi murder suspect Richard Allen will be back in court Monday, March 18th in Fort Wayne for 2 hearings in the case at 9 a.m. and 2 p.m. What's weird is that this time they didn't even have cameras on the outside to show the suspect. Normally we can see him, arriving at the courthouse and leaving, but I haven't seen any of that, which I know that most people, they do want to see, what kind of state he's in. So couldn't see that. And they say Special Judge Francis Goll has a few big decisions to make that will decide how the rest of the case moves forward. The court must decide whether Carroll County prosecutor Nicholas McClellan can add charges against Allen, who's accused of murdering Abigail Williams, 13, and Libby German, 14, in February of 2017. Now, you'll be surprised. There's still people, of course, who don't know about this case. If that's one of you, if any of you are here and you're like, what is this case about? Please check the description box. There's a case background write-up for you, as well as a link to my playlist, because there's plenty on there, lots of recaps and everything. So, on January 18th, the same day the Indiana Supreme Court reinstated Allen's original attorneys, the prosecutor filed a request to amend the charges. Remember that? On the same day they had that big hearing. Nicholas McClellan was like, okay, well, we're adding new charges. Like, okay. So the new charges were to also include 2 counts of murder while committing or attempting to commit kidnapping, previously filed October 28th of 2022, 2 additional counts of murder and 2 counts of kidnapping. McClellan said the added charges more accurately aligns the charging information with the cause's discovery and the probable cause affidavit. I've seen some attorneys out there say that it's more like he should have filed the charges like that initially, and he was really just correcting that. I'm like, okay. Well, we'll see if those charges do get added today. Do you think they will? McClellan said the added charges more accurately aligns the charging information with the cause's discovery and probable cause affidavit. One of the hearings is to discuss, that's now the second hearing at 2 p.m., accusations of contempt against Allen's attorneys, Andrew Baldwin and Bradley Rosie. McClellan argues the attorneys should be held in contempt of court for what he calls a trend of not being completely honest with the court. Really, McClellan? Have you looked in the mirror? Does he need a mirror? The prosecution said the attorneys violated the gag order in the case by issuing a press release on December 1st of 2022 proclaiming Allen's innocence. McClellan also points to information, including crime scene photos leaked to the public through Baldwin's office. Court transcripts indicate that Goll, previously that's Judge Goll, I've got a poll app for you, by the way, asking you, do you think that Richard Allen would have a fair trial with a new judge? Meaning not this judge. Because I don't think with this judge, I personally don't believe there could be a fair trial for Richard Allen with this judge. Anyway, let me know what you think. So they say, especially in the comments below, if you're watching the replay, Court transcripts indicate that Gull previously accused Allen's attorneys of gross negligence in the case prior to their removal, and the state Supreme Court's later reinstatement of them. So why is he still busy with this? The Supreme Court of Indiana reinstated them. What is he doing? McClellan's like, okay, let's have this fight again. Round 2. A recent court filing shows that Baldwin and Rosie are prepared to call at least 6 witnesses and present more than 26 pieces of evidence Monday. So that's going to be some interesting updates as well to see, well, what happened in those hearings, right? The attorneys have asked several times in recent weeks for the contempt hearing to be delayed. Do you guys remember last week we went through all those documents, everything the defense filed? Do you know what Judge Gull's response to all of that was? It was the courtroom decorum order, just like how people are going to conduct themselves, no electronics. Like, she didn't even address it. There's still things to address. Wow. Okay, so continuing on, then I'm going to get to those documents because you're going to see, I know you saw the thumbnail, we're going to go over that, okay? So they say that's what's happening today. There's YouTubers and podcasters and people being called to the stand, which is really unprecedented, and, you know, I've just never seen this happen in any other case. It's very strange, right? So the attorneys have asked several times in recent weeks for the contempt hearing to be delayed. The court denied multiple media requests for cameras in the courtroom during the hearings. After a request from Allen, the jury trial in the case is now scheduled to take place on May 13th until the 31st. The trial was previously scheduled to begin October 15th. 13 News has learned jury selection will begin on May 13th and take place at the Allen County Courthouse. Why is it there and not the Carroll County Courthouse? I don't know. Because Judge Gull is a special judge from Allen County assigned to the case in Carroll County. You know, I know that the defense brought this up as well. Like, listen, you got to be on the Carroll County turf, not your own turf. But anyway, we'll see. Once a jury from Allen County has been selected, the trial will shift to Carroll County. I should have read further. I read it before, but I'm just saying, what's so snarky? I was like, freaking Judge Gull, even today, it's there in Allen County. It will shift to Carroll County for opening arguments and continue there. We'll see. We'll see if it does. We'll see if there's even a trial. Is there going to be a trial? Is it going to be fair? I don't know. So now, let's just mute some of these. Hold on. Something is playing somewhere. Okay. Don't worry. Sorry. There was some sound playing somewhere. And I'm like, what? Okay. Let's get the documents. It was the sound of documents raining down on us. Here we go. Now, so this one is very interesting. Okay. Some of these shocking, saddening, and interesting. Okay. So this was filed today. No, today is the 18th. Yesterday, 12:48 p.m. So most of these say the 17th on there. Now, this is State of Indiana versus Richard Allen, amended motion to compel and request for sanctions. Comes now the accused, Richard Allen, by and through counsel, Andrew Baldwin and Bradley Rosie, and amends the motion to compel and request for sanctions, which was filed on March 12th of 2024. We read through that, okay? Stefan's like, the documents jingle. We do actually have a little document jingle. We do. I just don't have it right now. I'm not going to play it now. We don't want to have any more delays. We want to get into this. So, they say, so if you don't remember that document, go and check it out. But this is, of course, the amended one. They said, on March 12th of 2024, the accused filed his motion to compel the state of Indiana to provide certain answers concerning the existence of certain discovery, and if it existed, to provide the actual discovery. I don't really think they should have to ask for it like that at this point, you know, but okay. So, sorry, I made it a little bit too small. They say, on March 8th of 2024, the state of Indiana did in fact provide some of the answers to some of the questions concerning some of the discovery. Oh man, okay, well some doesn't sound like enough. Counsel's unawareness of this response is a result of a flurry of communications and filings that have occurred between the state, the defense, and the court since Attorney Baldwin and Rosie were reinstated by the Indiana Supreme Court. However, there is still outstanding discovery that the state of Indiana claims does not exist, when common sense causes the defense to believe that the evidence must exist. I'm really hoping that's not the data from Libby's phone, because that's the same language that we're using in the previous document, right? Therefore, based upon the state of Indiana's March 8th, 2024 correspondence answering a certified letter overnighted to the prosecution on February 20th of 2024, the defense can pare down its request concerning certain documents as the state of Indiana has answered certain questions concerning certain discovery previously found in paragraph 69 of the motion to compel and request for sanction. Therefore, the defense would amend paragraph 69 of the original motion to compel and request for sanction and ask the court to compel the state to produce the following. So they're asking again, clarifying again, exactly what it is they're asking for, right? Paula, that comment just flew by. You said Dawn, we need a judge from a different county. I think we need a new judge. Okay, so they said the state of Indiana provided 2 undated reports, never seen by the defense. I don't know why it's not dated. There's nothing detailed. It's just like, oh no. And it gets worse. The first report provided some detail as to how the state of Indiana explained that certain videotape recordings between February 14th of 2017 and February 20th of 2017, which would include Brad Holder's interview, were erased. Therefore, that request has been satisfied. So they know that those were erased, and they're like, okay, thanks, now we know. However, the other report details how all videos, this is just so shocking. When I read this, I'd like, in South Africa, we would say pireng oog, which means just like eyes like saucers, right? I was just like, wait, what? The other report details how all videos between April 28th of 2017 and June 30th of 2017 were also lost. Just when you think it can't get worse, it does. This is news to the defense, as the defense was aware that certain videos did not contain audio, but was unaware that videotaped interviews between April 28th of 2017 and June 30th, 2017 were missing. This is most concerning. Wouldn't you agree? Oh my goodness. Additionally, it appears to the defense that the report is incomplete, as it details attempts to recover the lost interviews, including purchasing some type of equipment from China to assist in recovering the lost interviews. However, that is where the report ends. It is unknown whether the equipment from China was ever purchased or if an attempt to recover the missing interviews was attempted. Ooh, this is bad, you guys. Stefan says, that's 2 months of interviews, right? Oh, man. So, okay. Let's just go here. Someone is talking about ads. I only merge after dark. I've got YouTube Premium. What I was hearing was not an ad. It was not. I've just got many tabs open. Okay. Monitoring many things. Okay. So based upon paragraph 5A, is that 2? Like 5AII? 5AI above. The defense requests the court to compel the state of Indiana to provide the complete, obviously, I mean, can you believe that they're asking this? Thank you, Don. The complete report of law enforcement attempts to recover the missing videotaped interviews. One would think. Based upon paragraph, the defense would be requesting the court to compel the state of Indiana to provide a listing of all persons. Now, it gets even worse, okay? Not only did they lose all the interviews, but they don't even know who they interviewed. Okay. Requesting the court to compel the state of Indiana to provide a listing of all persons whose interview was videotaped but lost. But unfortunately, according to the state of Indiana, there's no comprehensive written log that was used to document date, time, subject, and participants for each interview room. Okay, so have you ever heard of something like that? Where they don't even know what they lost. They admit they've lost 70 days. It's over a 70-day period, right, worth of interviews. I don't know how many interviews are there. And you know what? The state doesn't know either. That is so shocking. This is the state's case, right? Like, this is your suspect, but yet you don't even know who you interviewed back then and how many interviews you've lost. That is just, wow. Christy says, this is unbelievable. It really is, right? The defense seeks supplemental information as to which law enforcement individuals may have interviewed suspects and witnesses during that time period, and any reports reflecting the occurrence of such interviews and summaries thereof. Again, it is extremely concerning to the defense and Mr. Allen that potential exculpatory witnesses and statements are apparently forever lost, and not even a log of which witnesses were interviewed exists. Furthermore, it's very disconcerting that the defense just learned of this lost evidence, and only upon request of the defense of such a report, and more than 14 months after the defense should have learned of this lost evidence. totaling the missing days of interviews, February 14th to February 20th of 2017 and April 28th to June 30th of 2017, would show that the state of Indiana has lost 70 days worth of interviews and claims to have no ability to fully account for who was interviewed during those 70 days. I literally see people on social media saying, that's it, free Richard Allen, just let him walk. You know why? I almost agree with it, because they've botched the case. This is not okay. Yeah, Paula says he should be out on bail. I mean, he's in a maximum security prison. No, he's not even in a jail like a normal defendant, like we've seen Brian Koberger, Adam Montgomery, all these ones, even Daniel Howard, whose trial we're watching. We're going to be teleporting to that after this. I mean, I just think whether Richard Allen did it or not, the state has messed up the case. The investigators, the state, everyone, they botched it. Therefore, according to the rules, which would be fair, let him out. Right? CBC says, can I still be a Grizzly if I think RA did it? Of course you can. Of course you can. We can all differ in opinions. For me, for a while now, it hasn't even been about did Richard Allen do it or not. In my gut, it feels a little bit like he didn't. But even if he did, it's not about that anymore. It became something else. Like, what is this? So now it's whether he did it or didn't do it, they botched the case. That is terrible. That is unforgivable. So they said in its March 8th, 2024 response, the state of Indiana failed to produce similar reports explaining how the audio is missing on certain videos. The defense would request the court to compel the state of Indiana to issue a report detailing why no audio exists. Even that, when they originally interviewed the 5 Odinist dudes, to lose majority of those interviews and the ones that they still have no audio is so weird. Especially when one of those guys says that he spat on one of the girls. I think he said he spat on Abby's head. And he could explain that away. Would he still be in trouble if he could explain it away? I mean, what? Oh, man. Okay, and that involved polygraph tests and all sorts of things. And then the person who actually did the polygraph test was killed in an arson event. It is like this rabbit hole of this case. If one is not careful, you'll never come out of it. Okay, so if you're feeling like this is too much, don't worry, we all feel like that. Like, what is this? The defense requested the existence of certain it gets worse, phone dump data from certain phones. In response, the state of Indiana claims that no phone dump evidence exists from Kelsey German's phone, nor Mike or Becky Patty or Cody Patty's phones. And furthermore, that the prosecutor's office does not possess any phone dump data from those phones. Why not? Those are very important witnesses. Kelsey was the last person to see the girls alive. And you don't have any evidence from her phone either? For the timeline, as they say here, they're not accusing anyone. They're saying, so you don't even have the phone data from Kelsey German, Michael, Becky, or Cody Patty's phones. Like, how are you establishing this timeline that people are so reliant on to say that Richard Allen did it? Wow. However, it is still unknown whether that phone dump evidence did exist at some point in time, which question is more than fair considering the loss of 70 days of investigative activity as referenced above. It would be hard to believe that law enforcement would not have obtained the phone dump data from the parties identified in this paragraph, Kelsey German, Mike, Becky, and Cody Patty, to at least determine timelines. Because the state of Indiana has lost other important pieces of evidence, 70 days worth of videotaped interviews, the defense would therefore ask this court to compel the state of Indiana to answer as to whether the phone dump data ever existed, and if so, what came of it. The defense would compel the court to order the state of Indiana to provide all geofencing data and the names of the actual person or persons that interpreted the geofencing data, including the person or persons that reduced the geofencing data to a map that has been provided to the defense. In preparing for trial and for a contempt hearing and in reviewing newly discovered evidence, the defense and its limited staff has had limited time to fully review the state of Indiana's response and to compare it to the requests of the defense. However, for now, the defense would request the court to compel the state of Indiana to produce the items detailed in paragraphs 5 to 11 above. Wow. Wherefore the accused moves this court to amend its first motion to compel and to compel the state of Indiana to respond to paragraphs 5 to 11 above. So that's one down. There were 5 documents today. I'm going to share highlights of some of them. This was now the state's response to the defendant's motion to compel and request for sanctions, okay? So let's quickly do that. Richardson family says, oh my word, how many other cases did that affect? Imagine that. Yeah, those interviews don't just have to be this case. You're right, Richardson family. Truth and Justice said, it is a pretty sad state when we have to advocate for a likely guilty man to be freed, but that is the only justice left to find. It is. It is. It's pretty sad, but that's, it seems to be what's happening here. I would not be mad if they let him out today. Just let him out, because this is just embarrassing. This is wrong. This is not justice. This is not a fair trial. They messed it up. Oh, man. I don't know if it's fixable. Do you think it's fixable? Okay, so state's response to the defendant's motion to compel request for sanctions. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland. So he's now responding to them. And I don't think that this is the response to the amended one. Maybe. But it's a response because they've now filed 2. The one and the amended one. Okay, so I'm just going to go to the highlights. They say, when the defense has requested information, the state has endeavored to locate those items. Why are you endeavoring to locate them? When the state asks, we have tried to find them, okay? You should have it. You shouldn't be endeavoring to locate things after 7 years. You should have it ready to go. My goodness. Even when this and I'm not even a lawyer. Okay, even when this results in providing a duplication of prior discovery and when items appear to be irrelevant. The state's not required to hand over every lead and inquiry during the 6+ year investigation as part of discovery, much of which is neither relevant nor related to the state of Indiana versus Richard Allen. Well, guess what? If you don't have that evidence, you can't say whether it's relevant or not. You can't be the only one to decide if it was or wasn't relevant, because that was evidence that was lost. 70 days worth of video interviews. You don't want to lose 70 days worth of police video recorded interviews. However, the state has gone beyond the requirements of discovery and the information we have provided. When additional information is received, the state forwards it to the defense. No, you don't. They have to ask for it. They have to sniff out what they should be asking for, and then only do you hand it over. The state began delivery of discovery on December 7th of 2022. Yeah, that's many years later. The court ordered the state provide discovery to the defense by November 1st of 2023, and the state has complied with that deadline. Sure, when the state has discovered new items, the state promptly creates a copy and notifies defense of its availability. For instance, the state recently became aware that 4 interviews in 2017 were recorded on an iRecord device and had not been uploaded and attached to the ISP video recording and evidence. Another concern. They're like, oh wow, guess what? While we were looking for all the things we lost, we actually found 4 cool new things. Like, no man. What? They said these recorded interviews of Becky Patty, Mike Patty, Ron Logan, and Daniel Pearson were located. Like, look what we found by Detective Harper and have been immediately made available to the defense. Those are critical interviews. And you literally, while looking for all the stuff the defense is asking for, is like, cool. I didn't even know we had these. Really? Becky Patty, Mike Patty, Ron Logan, and Daniel Pearson? Okay, prior to November 1st, 2023, the absence of these recorded interviews in discovery was not known to the state. Wow, we can see you've never tried a murder trial ever. The prosecutor has never prosecuted a murder trial before, let alone a double homicide, a high-profile case 7 years later. The defense attorneys, whether you like them or not, are brilliant. They are very thorough. They have 50 years of experience between the 2 of them. And they are showing the state up. They are exposing the inexperience, in my opinion, based on what I know so far. I'm like, what? Oh my goodness. This is like, I'm very visual, right? McClelland's like digging in a box, like, ooh, where are those interviews? Cool. Look what I found. Guess what, defense? We have these 4 cool interviews. We haven't seen those in a while. In fact, we didn't even know we had them. Really? Okay, then. It's like, but never mind. It's not relevant. Sure. How do you know? How do you get to decide? The absence of these was not known to the state. The interviews turned over correspond to law enforcement narrative reports already contained in discovery and provided in February of 2023, and therefore it's not new information. They're like, listen, the reports were there. We just didn't have the interviews, okay? That during the course of this case, the defense asked the state to re-interview certain witnesses, and the state has done so and provided the interviews. That's of the Odinist dudes. The law enforcement geofence reports have been provided to the defense to the best of our knowledge, which means they haven't. To the best of our knowledge. I do believe, yeah, they were provided. Like, no, they really weren't. Actually, no. Kathleen R. said, I wonder if there are any unrelated case interview videos in existence with the 70 days. That would be even more sus. I know, right? So they said, still just to the best of our knowledge. Wow. In discovery provided to defense, one hard drive is missing interviews from February 14th, 2017 through February 20th of 2017. That's very critical that you decided to interview those people within the first week, days after finding the victims' bodies. You interviewed those 5 dudes and others, and then just like lost them. Whoops, lost the interviews. Okay, and one other hard drive contains video interviews without audio. The defense has been notified of the missing data and the events which led to the corrupted or lost files. Now, who corrupted them or lost them? Who tampered with them? We must ask ourselves. At this point, anything's possible. The state, now they say the state is at the same disadvantage as the defense. No, you're not. You're the state. You can't be like, listen, we have the same disadvantage now, okay? For the reason that the content of relevant interviews related to this case can only be identified by reviewing narrative summaries prepared by law enforcement and contained within reports disclosed in discovery in February 2023 and thereafter. The defense has mischaracterized the information specific to Professor Turco. Yeah, the guy who you pretended not to know his name. The guy, the professor that everybody was, as in the state and the law enforcement officers were like, we don't know. Well, you'll probably never find his name. We have no idea who that is. Meanwhile, behind the scenes, they had already found his name and were already talking to him. Now they say the defense has mischaracterized the information specific to Professor Turco. In reality, they requested the name of a Purdue professor, consulted by law enforcement based on a report in discovery that did not identify the author. The state endeavored to find such information, locating Professor Turco, and disclosed this to the defense. Yeah, but you hid it for 2 months. Don't lie now. You hid it for 2 months. Wow. And they're like, but we did give it over 2 months later. Yeah. Okay. The interpretation of his report is up for debate. Yes, that's normally how it works. The state has one theory, the defense has another. Maybe law enforcement's got one that aligns with the state. I don't know, but it's like, listen, this is up for debate amongst the parties. And Professor Turco himself states that the defense has mischaracterized his opinion. How are we supposed to trust that? After everything we've seen this prosecutor do and judge, how are we supposed to trust that, you know, that he himself said it? He even said it as well. Yeah, the defense mischaracterized it. If the defense would speak directly to Professor Turco, as the state has, they would know Professor Turco's opinion is not consistent with their characterization. Yeah, if you had actually provided the name when they asked for it, and they did find it, yes, they would have spoken to him themselves. It's like, so, it's almost like immature in a way, a little bit, right? Contrary to the defense's representation, the state did respond to the defense's certified letter of February 20th, 2024, and provided the defense with our response on March 8th, 2024 by email and by e-discovery. That the state has not intentionally withheld discovery, I beg to differ, and therefore sanctions and attributing delay to the state is not appropriate. Yeah, talk about what's not appropriate, sure. And wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McClellan and files their response to the defendant's motion to compel and request for sanctions and would ask the court to dismiss this motion without a hearing. The nerve. The absolute nerve, right? Okay, now this document is pretty interesting. And let's just see, wait, this one? Okay. This one is about the mental health records that Nicholas McClellan, the prosecuting attorney, wants, and he's saying state's motion to enter protective order for evidence gathered from the Indiana Department of Correction. So whatever he wants there, the records, he basically he's asking for a protective order, would ask the court to consider the same and for all other just and proper relief in the premises. Like, I don't know if he's going to get it or not, but he's like, don't worry, I'll keep it a secret. It'll be a protective order. No one can get it. Are you sure? I don't know about that. And here they said, state's notice of submission of supplemental witness or exhibit list to the defense comes now the state of Indiana by prosecuting attorney Nicholas C. McClellan respectfully notifies the court that the state has turned over a supplemental witness or exhibit list to the defense outlining the witnesses the state may call and the exhibits the state may use at trial. The state may supplement the list if new witnesses and or exhibits are obtained or if the state deems that additional witnesses and or exhibits are necessary. Well, at least that's one silver lining. McClellan's thinking of the trial. He's like, okay, well, for the trial, we'll have additional witnesses and exhibits. Oh, so you know there's a trial. And it's happening on May 13th, by the way. That is for like 50, how many days away? 55, 54? We'll have to look again. Scooter McBooters, welcome. Okay. Bonnie said, did you see the hippo video? No, I don't really look at Facebook. I only use it to watch press conferences. Anyway, so now we're going to look at this one. I just want to check something. Mandy said, if there's a mistrial, the family will never know who murdered their girls, and Richard Allen will always be considered guilty by many. Not sure which is worse. Who's going to take responsibility? Exactly. At this point, the way things are going, with Judge Gold and that prosecutor and everything, I just don't think there can be a fair trial for Richard Allen. And therefore, there will always be questions, and I don't know if there will ever be, will there ever be true justice for the victims? Because that's what it's about. Yuli Jade said, Libby and Abby deserve better than this clown show. Yep, they do. Blueberry Art says, prosecution has been very naughty. That's how I read it. Very, very naughty. Okay, so look at this one. Let me just check the time. Okay, we're still good with time. Motion for parity in resources to reconsider the denial of anticipated defense costs or to exclude evidence. So I'm not going to read the whole thing because it's pretty long. 17 pages. We'll be here forever. But I'm going to read this beginning part and then skip two parts where they talk about critical evidence, which is very interesting, right? Teresa says, Gisela, best channel by far. Oh, thank you so much. To the accused, Richard Allen, by and through counsel, Andrew Baldwin, Bradley Rosie, moves this court to issue an order designed to provide parity in the resources available for investigation and presentation of litigation. That's quite a sentence, that, hey? For investigation and presentation of litigation in this proceeding. To balance the scales of justice, Allen asks that the prosecutors working for the state be required to pay out of their personal finances for investigative services, evidence processing, and expert fees, as the court's recent order has effectively reduced Baldwin and Rosie to a position where they are required to personally advance those expenditures for Allen's defense. So they're like, we're not going to pay that. Let the prosecutor pay out of his pocket. Now, I know that people that don't like the defense are going to say, what? You offered to work pro bono, so why are you even asking for this? Well, I think they've got pretty strong and valid points, especially when they point out again, that they haven't been paid along the way before they were even dismissed the first time and all of that. Lenny, he says, #justice for Abby and Libby. Yes, Lenny, thank you so much. If you haven't yet liked and shared the stream, please do so now with that hashtag. So they say, alternatively, Allen requests that this court prohibit the state from offering any testimony or evidence at trial. So it's either like you're going to pay out of pocket, or alternatively, Allen requests that this court prohibit the state from offering any testimony or evidence at trial related to the bullet found at the crime scene, the digital data collected by law enforcement, or Allen's alleged confession. Oh boy. I quite like the chess game that these defense attorneys play. They're like, checkmate again, putting you in a corner, just like they put Judge Gold in the corner. So are you going to free him, or is the trial going to be on May 13th? Is it going to be a speedy trial, or are you going to let him walk? And they're like, okay, speedy trial. Based on how the procedures go, right? So they said relevant facts and procedural history. Allen's defense team consists of the following 7 people. So if you don't know, attorneys Rosie and Baldwin, Matt Hoffman, a retired fire chief of Carmel, who has been instrumental in sorting through tips and sorting through and analyzing evidence and is a key resource for the case. Max Baker, a full-time student at IU Bloomington, who assists and he is able, including full-time over the summer of 2023. Brad Rosie's paralegal, Sarah, who assists with administrative tasks related to the case. Andy Baldwin's paralegal, Sarah, who assists with administrative tasks. Is it the same Sarah, or are there 2 Sarahs? I don't know. Brian Elvey, investigator who has tracked down and spoken with key witnesses, as well as performed other tasks. Additionally, for a very short period of time, the defense had utilized another investigator out of Utah due to his experience, but found the geography interfered with the ability to perform the functions needed in Indiana. Now the rest of this now up to the point where I highlight is all about complaining about the funds and things. We can read it sometime, but I just want to make sure it's not like too long now. I don't want to bore you. I want to get to this stuff right here. Okay. They say, this is page 4. At the very least, there are 3 pieces of evidence critical to this case. The bullet, purportedly found at the crime scene, digital data pulled from cell phones belonging to the victims and other individuals, and Allen's purported post-arrest confession. Allen's request for funding related to obtaining expert assistance to investigate each of the 3 critical pieces of evidence and for general assistance given the enormity of this case is reasonable. Mrs. Melissa's like, they probably don't know how many Sarahs there are. Well, this is the defense. They probably do know, right? The first piece of critical evidence is the bullet, purportedly found at the crime scene. The state utilized the Indiana State Police Crime Lab's firearms unit, which employs 15 people. That doesn't sound like a lot, right? Okay, 15 people to examine the bullet found at the crime scene, the unspent round, right? Defense counsel retained a firearm or toolmark expert to conduct an independent analysis and to assist them in reviewing the crime lab's analysis. The funds needed to retain the firearm or toolmark expert and begin working on Allen's case were advanced by Attorney Rosie in the amount of $2,550. Defense counsel requested reimbursement for that amount, as well as authorization to pay the expert for additional services needed to prepare Allen's defense. This court authorized reimbursement for the amount Attorney Rosie had already paid, but denied the request for defense counsel to continue receiving the expert services, finding that the request was unsupported. Okay. The second piece of evidence, remember they're public defenders, the second piece of evidence is the digital data collected from various sources, including cell phones, location data, and social media data. The state utilized the Indiana State Police Crime Lab's Digital Forensic Unit, which employs 14 people, to examine the large amount of digital data collected in this case. Defense counsel retained a digital forensic expert to help them decipher, interpret, and analyze the digital data. The funds needed to retain the expert and begin working on Allen's case were advanced by Attorney Baldwin in the amount of $3,712.50. Defense counsel requested reimbursement for that amount, as well as authorization to pay the expert for additional services necessary to prepare Allen's defense. This court authorized the reimbursement for the amount Attorney Baldwin had already paid, but denied the request for defense counsel to continue receiving the expert services, finding that this request was unsupported. Now, I don't know what we're supposed to be thinking of that. I don't know if that's normal or not. I think lawyers would know better, but I'm like, okay. The third piece of critical evidence is Allen's alleged confession. The state has utilized investigators, police officers, and experts from the Carroll County Sheriff's Department, the Indiana State Police, the Delphi City Police Department, the FBI, the U.S. Marshal Service, the Indiana Department of Natural Resources, and other law enforcement agencies around the state to assist in the investigation that led to Allen's prosecution. Allen's alleged confession was obtained while Allen was held for safekeeping in solitary confinement in the DOC. Since being reinstated in this case, the state of Indiana has served up additional discovery to the defense in the form of multiple interviews conducted by law enforcement with Westville prisoners and correctional officers. In these interviews, law enforcement investigators have inquired about the interviewees' opinions regarding defendant Allen's state of mental health, practically seeking clinical diagnostic opinions from these lay witnesses. They want the other inmates to armchair diagnose Richard Allen? Yeah, I don't know about that. I don't think that's how that works. Defense counsel retained a clinical psychologist to evaluate Allen and review health records and video relevant to Allen's confinement conditions. This court previously authorized funds for the defense to retain the expert. However, those funds are now depleted and additional services are still needed. Oh, wow. What? Criminally focused says Snade just got kicked out of the court, apparently. Why? There's going to be drama, I know, from today. There's going to be updates later, which is why I wanted to do this live stream now. Don't worry, this is not the only update we'll do. Of course not. I wanted to tackle these documents now, because there's going to be news from today's 2 hearings. I'm sure of it, okay? I'll be lurking everywhere after the trial, probably in the middle of the night. So they said this court authorized payment for the 2-hour visit defense counsel had scheduled with the expert, but denied the request for additional funding, finding that the unsupported request is denied as an unreasonable expenditure of county funds. Unreasonable. Why'd you put him all the way there then? 4 hours away or whatever it is. Long drive. My goodness. They're just like, no, it's just unreasonable expenditure, okay? Who cares about his mental health? And now McClellan's like, I want those records. Those records that you got, that you initially paid for, that, yeah, they were reimbursed, but you can't have any more. I would like to take some of that. Like, okay. Defense counsel also requested funding to hire a confession expert to educate counsel and possibly the jury on the impacts solitary confinement has on individuals accused of crimes, particularly in relation to the voluntariness of a confession made in those conditions. I do think it's a valid concern. I do. Okay. Through the process of conducting discovery, defense counsel has learned that defendant Allen's pretrial detention in the segregation unit at Westville may be the first time an innocent man has been confined in such a setting in the history of the institution and possibly the state and possibly the whole of America. Huh? Moreover, Allen's detention is the direct result of the Carroll County Sheriff's request for a safekeeping order. He, the requesting sheriff, created this circumstance. I agree, he did. It is indisputable that the issue of the impact of Allen's unique and unprecedented pretrial detention circumstances on his overall mental health is germane to his defense. Despite this, the court declined defense counsel's request for additional funding as being unsupported. That's what I'm saying. The conditions are so bizarre. Like, it's such a strange red flaggy situation, but they won't even have a psychologist, like, continue to find, like, okay, we need some more testing done. We need to check. No. Sorry, unsupported. Defense counsel made other requests for funding as well. Counsel requested funding for the services of an independent forensic pathologist to review and consult with the defense on issues related to the crime scene, the pathology of the victims, the cause, manner, and timing of death. This court declined the request as being unsupported. Defense counsel requested funding for additional in-office assistance services. The state has enlisted the help from at least 2 other prosecutors as well. 2? I know about the 1. Okay, but as well as an untold number of law enforcement officers and their support staff, as well as the prosecutor's support staff. In February 2023, the Carroll County prosecutor obtained funding to hire a full-time investigator, a full-time secretary, and a special prosecutor, all for this case, and raises for himself his current secretary and his chief deputy prosecutor, given the additional hours that they are working on this case. He told his county counsel that his office was drowning right now and needed more people to work on this case. There is a video of that on YouTube. Yes, indeed. Well, Frankie said they're supposed to have the other hearing at 2, but this hearing might take all day. I also think it will take long, right? They've got a lot of witnesses they're going to call today for this 9 a.m. one that started already, of course. It could take all day. The 2 p.m. one was supposed to be, or is going to be, the contemptuous conduct one. You said, does anyone know who the YouTuber is that was called to testify in the closed hearing right now? Yeah, we know. We went over the documents. There's quite a few of them, actually. It's not just one of them. Rick Snay from Delphi After Dark. We've got a few witnesses from The Unraveling from that channel as well. There's quite a few, actually. They might even show some YouTube videos, yes, as exhibits. So, they said, recognizing the uniqueness of this case, Carroll County appropriated an additional $2.1 million in funding for Allen's case. In addition to assistance from the law enforcement agencies and the multi-site Indiana State Police Crime Lab outlined above, as well as the assistance the state received from hiring more employees to work on the case, the state has received help from forensic pathologists, a university professor, DNA analysts, voice data analysts, cold case investigative units, search and rescue units, helicopter pilots, drone operators, and fingerprint examiners. Even as this motion was being prepared, the state filed an amended exhibits and witness list. We saw that. Not the list, we just saw that they were going to add more witnesses and exhibits, identifying no less than 3 new and not previously discovered experts. So here they say Ronald Nichols, toolmark ID, David Schilling, odonism expert, and Pat Cicero, blood pattern or stain analysis expert. The state's resources, both financial and from a personal standpoint, are endless. And it's funny because the state says the same. The state is like, no, but they're public defenders. We're at a disadvantage. To date, the Defense Council has received 25 hard drives containing at least 40 terabytes of information, plus an additional 300 gigs of e-discovery. The state has investigated this case and collected this information over a period of 7 years. Defense Counsel has only had 1 year to organize, catalog, and review this massive amount of discovery, while also screening and investigating dozens of tips received weekly and identifying and retaining experts. Attorneys Baldwin and Rosie have each employed an in-office assistant to help them with the discovery, payable at a rate of only $15 per hour. Oh, interesting, Mandy. It should be noted and not understated that the state of Indiana has violated the local rules on discovery by dumping massive amounts of discovery, much of it exculpatory in nature, on defense counsel well past the discovery deadline, forcing the defense to work beyond their capacity to view and analyze the evidence over the course of a very short period of time, rather than over the course of months. Richard Allen, on the other hand, remains isolated, now in solitary confinement unit, oh my goodness, in the southwest corner of the state, some 175 miles from the location where this case is pending. Certainly not within a reasonable range for any sense of routine visits by his lawyers. Why did they put in there? While they are completely inundated with trying to keep up with newly received discovery and trial prep. While all of this is ongoing, Prosecutor McClellan has violated the discovery order, causing delays and difficulty for the defense. Due to McClellan's discovery violations, the defense needs funding for additional staff to review untimely discovered documents. Defense counsel requested additional funding for the 2 in-office assistants, otherwise they'll be forced to pay for the assistant's services from the $100 per hour rate that they are receiving as Allen's lawyers. This court denied the funding request, finding that one assistant's invoices had been inadequate, and the need for the assistance was unsupported. Oh no, I just have to have a sip of water quick. There we go. I'm back. So we've got to keep that voice intact. I talk a lot. This court's denial of funding ensures an unfair, inequitable trial. What do you guys think? Underlying every facet of the criminal justice system of Indiana and the United States of America is the immutable principle that citizens targeted and charged by the state for prosecution will have a fair opportunity to protect their liberty, including the opportunity to investigate the charges and the evidence and to defend themselves. The scales of justice must be carefully balanced, and the courts are the fulcrum of the scale. It is the duty of the court, having defendants' cases in charge, to see that they were denied no necessary incident of a fair trial. Perhaps the most critical period of proceedings against the defendant is from the time of their arraignment until the beginning of the trial, when consultation, thorough ongoing investigation, and preparation are vitally important. Yeah. One wouldn't think. Yes, that's what they should be doing. Consultation, thorough ongoing investigation, preparation for the trial. Everybody remain calm, prepare for the trial. But no, McClellan is throwing mud. The comprehensive plan for indigent defense services in Carroll County subsection requires that assigned counsel such as Baldwin and Rosie request ex parte authorization from the judge hearing the case for expenditures for investigative services, expert witnesses, or other services necessary to provide adequate legal representation. To comply, Baldwin and Rosie have submitted detailed ex parte requests for expenses already incurred and for expenses expected, which of course McClellan read, which he should know. The court has denied all requests for anticipated expenses and costs that have not yet been incurred, excluding one, services for a private investigator, and stated that it may authorize expenditures for paralegal services. However, for the investigative and paralegal services, the court has instructed that it will require detailed invoices, meaning that Baldwin and Rosie will have to carry the obligation to pay even those services out of pocket until such time that the court may find that the invoices are adequate and services are necessary. For several reasons, this court's denial of offer to pay for anticipated services and costs necessary to defend Allen, and, of course, they're public defenders, of course, and requirement that Baldwin and Rosie front the obligation to pay for the very limited investigation and litigation support that the court offered to potentially reimburse for denies Allen the following: due process of law. So denies him the following, right? Due process of law, the opportunity to the free administration of justice, due course of law, and privileges and immunities. It also imposes upon Baldwin and Rosie obligations without just compensation, altogether working a fundamental denial of an opportunity of a fair trial. I see majority voted earlier that you don't think with this current judge there could be a fair trial. Maybe with a new judge, right? Yeah, Evil Queen says they dropped the ball. I think that sums up the case pretty well at this point. It's very sad. It really is. But it is what it is. You know, when one is not in denial and you can actually face the scary thought that, damn, they dropped the ball. Yeah, it just is like that. I think eventually everyone will have to face that. Like, damn, they dropped the ball is what it seems like. Of course, this is the defense saying all these things. I understand, but they can't just make up stuff. I know a lot of people say they just make up whatever. They're just feeding the media and YouTubers and they just make up stuff. They can't just make up stuff. They're following the law. They're doing their job. I think they're doing a very good job. Even though they made some mistakes, I think they're doing a good job. Pernille is reminding everyone, please don't be combative with each other in the chat. Please don't. Yes, please don't. We can all have different opinions. It's all okay. So, and I mean it. I don't mean like, hey, we can have different opinions and I'm going to scold you if you think differently. You know, I'm mostly just reading the documents anyway. People like to argue with me in the comments and I'm like, when have I even stated exactly what my opinion is? I'm just like, damn, I'm looking at this and saying, this is so not okay. Okay, so the rest of this is all, you know, financial related and all of that, right? And I understand exactly the points that they are making. Request for relief. Let's go to this one. Allen requests that attorney Rosie be reimbursed for the invoices that he submitted in October of 2023, which covered his legal services. Have they still not paid that? Okay, his administrative services and the services of his investigator. These invoices totaled over $51,000, as you can see, and were submitted to this court on 3 occasions. What? Is this like a money problem? Do they not have it? Is that what's awkward? Is that the elephant in the room? For the prosecutor and the judge? I don't know what's going on here, but like, why are you doing this to these attorneys as well? The court has ignored Rosie's request now for 5 months. My goodness. Rosie has staff to pay and a family to feed, and this refusal or unwillingness to even explain why the court has not paid Rosie is inexplicable. Oh man. However, the main thrust of this motion is related to Richard Allen's right to a fair trial. To balance the scales of justice, Allen requests that 1 or 3 potential remedies be ordered. Preferably, this court should reconsider the denial of funds for defense investigative and expert expenses as requested in the most recent ex parte motion. Alternatively, this court should exclude, again, it's like putting them in the corner, you're either going to do that or you're going to exclude at trial any testimony or evidence related to the bullet, the digital data, Allen's purported confession, and the cause, manner, and timing of death. I understand why the defense would want those things out, right? Those are the things they have that we know so far against Richard Allen. So it makes sense. They're doing their job. They're doing it well. It's not anyone else's fault, but the prosecutor, the state, if they are not doing their job properly. If they're not doing it well, if they are not winning, it's only their fault. I know people want to blame others, but really, if the others are stronger than you and they're doing a damn good job, well, better buckle up. So they say Allen's purported confession, cause, manner, and timing of death. Finally, if denial of the defense's request remains and the state is allowed to proffer testimony on the critical evidence discussed above, the only truly equitable relief would be to order the Carroll County prosecutor to pay for any expert and investigative services from this point forward out of his own personal finances. Whoa. Wherefore, the defense requests this court to there's only one more page, to reconsider its denial of anticipated defense costs, including administrative costs, and including those costs associated with expert witness preparation and trial testimony. If you're getting bored of the document, just hang in there. We're almost done with this, and then I'm going to just quickly look on X if there's any updates, with what's happening from the first hearing, because I'm sure there's some tea there, and if it's spilled, we're going to read it. They say, including admin costs, including the costs associated with expert witness preparation and trial testimony. In the alternative, the defense requests the court to exclude all witnesses who would testify as to any matter in which an expert could have assisted Richard Allen in his defense, but due to this court denying expenses for expert witnesses because of the court's belief that such requests are unsupported, will deny Richard Allen access to the same opportunities as the state of Indiana, ergo violating Allen's due process rights. In the event that the court is not willing to grant relief consistent with one or both of the aforementioned prayers, the defense requests that this court order the state of Indiana, through Prosecutor McClellan, to assume the expenses of all experts. Now he must be crapping his pants. Oh, he's angry boy. He's like, Judge Gold, look what they're saying to me. Okay, law enforcement officers, administrative staff, and any other expenses arising out of the prosecution of Richard Allen from this point forward from his own personal finances. These requests are made to level the playing field between the accused, Richard Allen, and the government, with its infinite amount of resources, all of which are currently being used to overwhelm Allen and his understaffed and underfunded legal team. Okay. What do you guys think? Truth and Justice says prison is for convicted criminals. That alone is a violation of his rights. It is. Okay, so I'm quickly going to go here on X, and I just quickly want to see if we go hashtag Delphi, and we've also got to do hashtag Richard Allen. There's 2 hashtags to look at. So, Vanica Law said, in the most high-profile investigation Indiana has ever handled, the state of Indiana has lost 70 days' worth of interviews and claims to have no ability to fully account for who was interviewed during those 70 days. Wow, okay. Sure. Okay, I'm just taking a peek there. Well, let's just take this off quickly. And now there's a Freddy flying around here. Okay, just quickly scroll. Someone says, what in the world is going on in Delphi? Everyone should be asking this. Yes. And someone said, okay, who was the YouTuber at the Delphi hearing this morning that Court TV says got into a scuffle in the courthouse with someone and was booted? Well, we heard it here. Apparently, allegedly, it was Rixney from Delphi After Dark. And apparently, allegedly, he's upset that people are bringing his wife into it. I've seen some of those concerns that he's had, and I must say, leave his family alone. How about that? Okay. Trevor said that was a very significant motion, right? Welcome, Travis. Tell us what you think. Oh my goodness. David Gray says, warning people, Indiana's not a state you ever want to visit, let alone live in. Be warned. Oh man, I think it's got potential, but whatever's going on here, I don't know, man. It doesn't feel right. Okay, let's quickly have a look at this. Nope. No, there's nothing really. Nothing really going on yet. So that means that we will be back probably tomorrow, because we're going to be busy with the Daniel Howard trial for the rest of the day, or for me, the evening. That is what we'll be watching, because that's also like, wow, the things that have happened in that trial, you don't want to miss that. Have you ever seen a trial where a defendant makes a run for it, or tries to, right before closing arguments? Ooh, my word, it happened in this case, so I hope the jury doesn't know about that. We shall see. I hope not. It seems to just be continuing, which is great. Okay, so this stream will teleport you to that one, which is all about the Daniel Howard trial, an Idaho case. So come and watch that with us. And then as soon as I get all the news, all the things that happened in that morning hearing, and then of course now the afternoon hearing is happening right now, which would be for the contemptuous conduct. That one I'm a little worried about, because I've seen it speculated that will the defense team be arrested is one speculation. People are saying, Judge Cole has been so, I don't know what word to use. Biased. Okay, there's a good one. From what we could see from the outside looking in, the whole world is watching, that it's plausible to say, is she going to arrest the defense attorneys? Is she going to fire them again? I think then the Supreme Court of Indiana will step in again and be like, what are you doing? We told all of you, just focus on the trial. Is the prosecutor going to go? Is no one going to go? Is everyone going to get scolded in private? Are we going to get transcripts eventually? I don't know. I don't know what's going to happen. It's just like so uncertain, and that's also not a good thing. Trust has not been built, right? It has not been built in this case. One should be able to trust the judge, law enforcement, and the prosecutor. And I know how many people badly want that. Of course, everybody wants that. Sometimes, though, you can't. Sometimes you just got to see it for what it is and be like, oh my word, run. So, I'll keep you posted. My point is, there's going to be more. There's definitely going to be more Delphi updates. So if that's what you are here for, make sure you are subscribed. hit the notifications, and then this will now teleport you to the next stream, and I'll put the link in the chat for you so you can join me over there. I've delayed it a bit so we could defluff, okay? If I need to just set it a bit earlier again, I'll go monitor now to see what's going on. Because we want to skip lunch and breaks and everything. But we do want to see what's happening today. So I'll see you over there. Thank you so much, mods. Thank you so much, everyone. Please leave your comments below because I can't wait to read them. I want to hear what you think about all of this because it's unbelievable to me. Oh my goodness. Okay, see you there. Bye.